My name is James Clark. I'm an injured worker out of the state of Idaho. I will be going to the federal courthouse here in Portland, Oregon, on Monday. Elaine and I, to show the fraud that's been committed against me in relation to federal law. Since Miss Racheal Obar from the firm Anderson, Julian Hall likes to try to take advantage of injured workers and then lie throughout her filings, and then help protect the state insurance fund of their fraud, as Mr. Lynn Luker did. This brief here that went to the Supreme Court, as you can see, is altered right up here. It says, you know, January 22nd, 2013. This also says January 22nd, 2013. And this here, the undersigned does hereby certify that the electronic brief submitted is in compliance with all of the requirements set out in Idaho Appellant Rule 34.1, and that a CD with an electronic copy was served on each party at the following address. Just me. But I never received it. Not electronic, because Steve Kenyon, clerk of the court, which I have email of, and in audio conversation, nobody files anything electronically to the Supreme Court. But now what's this? This is from Racheal Obar from the law firm, stating that they did it electronic filing. See, there's her name, Miss Racheal Obar, dated, you know, Racheal Obar for the law firm, dated the 22nd. Okay. All right. Yeah. Come on, Miss Obar. So, what I'm doing is on Monday, Elaine and I will be going to the federal building in downtown Portland, Oregon, because I won't get justice in the state of Idaho and their judicial system, especially with Lynn Luker involved. This is what they stated in their brief. This is their brief, supposedly, but you can't find it. But this is a brief to a Supreme Court. Okay? See, it says right there. Right over here. Right over there. Supreme Court. Okay? And that's where the date is a little twitched around from January, because if you remember right now, there's an audio out there where Miss Racheal Obar is not being honest with me in regards to something happened in January of 09. So, and then to have these documents that are altered from January of 09, I mean, that has January, and then you can clearly see that the 2013 that's put on it is altered, added. So, this is what she states in this, that I thought it was somebody else that had wrote it. But geez, Miss Obar, again, this has got your signature on it. So if it's got your signature on it, that means you wrote it. See? On the same document, same thing, okay? But this is what you write, Miss Obar. You write, yeah. Oh, I lost the place I was at. Substantial evidence. Let's see here. Required to formulate treatment therapy. Let's see here. Let's see. Let's see here. February 6, 2008. Claimant was evaluated. The Holy Rosary Man by Dr. Clean following a Yeah, 34. Claimant advised that he had been clean for years, but 2 days prior to came into system. So let's see here. Okay, I'm gonna have to start. Oh, here it is. Sorry it took so long to find it. So much garbage in this shit. Right here on her respondent's brief on page 23, because you see, this brief was supposed to be in regards to my appeal before the Idaho Supreme Court in regards to the findings of facts and conclusions of law that Mr. Donahue and the commission as a whole put together. So, they state right here that was the commission's decision as to each issue at hearing, claimant's entitlement to additional medical care, temporary disability benefits, permanent partial impairment, permanent disability, and attorney fees, supported by substantial and competent evidence. Has appellant raised significant grounds to set aside the commission's decision based upon procedural and evidentiary rulings before and during the hearing? Well, no, because you see, they have in their findings of facts and conclusions of law that if you look it up, it's posted, that I had fired an attorney, Roger Brown. Now, Roger Brown used to work for this law firm. Get your law office, okay? But the way that this is why I was arguing the findings of facts and conclusions of law, not about whatever was before the hearing or anything like that, because they had stated in their findings of facts that I had fired this attorney right here, Roger Brown, from the law office of the Get Your Law Office, our law firm. Okay? Here it is. Now, if you want to freeze it and actually read the real reason why they left, you may. But, this is the real reason why he left. Reference, workers' compensation claim dated of accident of April 17th of 2008. Dear Mr. Clark, thank you for contacting the Get Your Law Office regarding your workers' compensation claim. Unfortunately, I regret to inform you that our office is unable to represent you in this matter. As Paula mentioned to you this morning via telephone, my associate, Roger Brown, will be leaving our firm. As such, I will be taking over a portion of his current caseload and not have the time necessary to dedicate to your case. You may wish to contact Idaho State Bar Referral Service at 525 West Jefferson, Boise, Idaho, 83702-208-334-4500. Thank you for contacting the Get Your Law Office, and I wish you the best of luck in pursuing your claim. Finally, I have enclosed all of the original documents that you provided to our office. And plus, they also, had received a few while they had it because of the letter of of August 21st, which they're stating in this one, in this report, the one that they did in regards after the hearing, defendant's post-hearing brief of the hearing of November of 2010. But anyway, but you know what? They've got in there that I fired this gentleman because I didn't like the way that he was handling my claim. Now, that's a lie, and that's what I was arguing. And I sent this. I mean, you can see that there's pages on it. Even up here it says Supreme Court filing. I mean, it's now let me tell you. You want to know who is vice president of this law firm? I'll tell you. Lynn Luker. Lynn M. Luker was vice president of this law firm that I found out. And then they put this in the findings of facts to help Lynn Luker's lien that clearly I didn't sign no contract with. But there is a contract, I guess. But then the way I'm writing it, if there's a contingency fee or something like that, then I have to write it myself and give it to him. I didn't do nothing like that. I didn't sign no contract with Mr. Lynn Luker. But you see, because Lynn Luker quit on me. He quit on my Social Security disability. He quit on, he's a quitter. He quit on my Social Security in September. Let's see, September, October, and part of November. Jeez. He had my case from the day one that he had my Social Security in January of 2010 all the way up to September of 2010. But he didn't mention any of it in the records. Why, Mr. Lindluker? Why did you not mention anything in regards to my Social Security? Why didn't you mention that they were also looking into my county? You see, Mr. Lindluker, you're a quitter. And if in fact, if whatever happened, and if Miss Racheal Obar, because she is trying to tell me that something happened in January of 2009, but she won't tell me what, other than it's been heard. So, Mr. Lindluker, if you were also involved in putting this all together, because why would you quit? Why would you quit in regards to my accident when you clearly put together a settlement offer on June 11th of 2008? I mean, 2009, Mr. Lindluker. 2010, you put together, July 11th, a settlement offer, because you kind of threw it in the wordings, as I mentioned earlier, how you just threw it in there. But the overall was $798,000, Mr. Lindluker. Why would you want to quit on somebody when you write something like that? Clearly. Because I'm going to tell you what. In this one, and in this one, clearly, that's not what the state insurance fund is, or their attorneys are stating. Miss Racheal Obar, who stated stuff in this one also that clearly, you son of a bitches, I will have you held accountable. So here we are. There's the letter that I sent to the Industrial Commission to request for a new hearing based upon findings of facts, and they're wrong in the records because they're trying to help Lindluker get his lien that he filed after he quit. Because I got documents that shows that Lindluker did not file his lien until December 27th. But he was already granted, and he had already withdrawn, and he was no longer my attorney as of the 23rd. Because he withdrew on the 20th and granted on the 21st. There it is. And then I had to go pick up the records from the Industrial Commission on the 23rd. So, there you are. I am going to the federal courthouse in Portland, Oregon, in regards to Drew Loans' fraud. I've already been there once, but this time it's going to be a little different. Because I think I'm entitled to justice here. Clearly, Miss Racheal Obar has done nothing but lie. I have audios of her, you know, even phone records that they were recording of me and then sent me copies of. But then again, I've done recordings, and now I'm a bad person. Well, they only wish that I wouldn't have made it this far, because I wasn't supposed to make it this far. Now, was I, Miss Obar? Or was I Mr. Lindluker? You know, if an attorney would take me. So, there we are. If you'd like to stand and support me and my lady to make people be held accountable for their actions, then meet us there. Meet us there at the federal courthouse on downtown Portland. You can't miss it. It's 1 block away from the courthouse on 4th Street. So it's on 5th and Yamhill or something like that. So, we'll see you soon there, Miss Racheal Obar. And you want to state all these damn lies about me, man. You're going to pay for those lies.